On behalf of the ICRC, CERAH and our co-organisers, MSF, UNHCR and the Refugee Law Project, it's my pleasure as Director of International Law and Policy for the ICRC to really warmly welcome you to this evening's discussion on a persistent challenge that faces survivors of sexual violence, that is, achieving concrete and meaningful justice. Now, the subject of our discussion today actually is one that I've personally felt very committed to over many years. I, in fact, came to the area of international humanitarian law as a professional wanting to seek clarity around issues of sexual violence and war crimes. Because whilst sexual violence has been one of the oldest prohibitions under the rules of law, on paper, this was not matched to accountability until much more recently. And indeed, it was through a series of groundbreaking cases at places like the Tribunal for Rwanda and the former Yugoslavia that we actually saw advances in the capturing of terrible human suffering and the holding of individuals to account. And in fact, I must admit, I will never forget the memories of being a young ICRC delegate in the field, talking to women who were survivors of sexual violence and explaining to them about these jurisprudential developments. And initially I was a bit nervous because I thought they might be frustrated or upset that they hadn't got justice. But it was very moving to see their clear understanding. And in fact, one older woman said to me, "I know now what happened to me is not just an inevitable consequence of conflict, but it's deemed illegal." So I think there is much hope in some of those elements. But these, what we would call bright spots of justice, sadly remain the exception rather than the rule. And sexual violence in conflicts and crisis, as we know today, continues. And as perpetrators use rape as a tactic of war, abuse positions of power in detention, take advantage of hunger and desperation, we know more must be done. And despite this prevalence of sexual violence used on all those, often in situations of vulnerable and situations of need, barriers for survivors of sexual violence are very high. And in fact, as we know, sexual violence remains one of the only crimes in which society often stigmatises the victim rather than the perpetrator. And beyond stigma, we know in the ICRC there is a real risk of and fears of retribution, the incredible cost often accompanied the access to justice, the lengthy and sometimes re-traumatising process that too often makes it almost impossible for victims and witnesses to come forward. So where do we go to from here? And I'm really happy we've got a very eminent panel tonight who will be able to unpack and provide some ideas and solutions and reflections on the need to move forward. But before we hear them, I'd like to just pose two reflections to maybe get us started. The first one is that we know that domestic systems, legal systems, are critical on this issue. States have legal obligations that flow from their international humanitarian law obligations, and they have real obligations to investigate, prosecute, and punish wartime sexual violence under their domestic law. And in some cases, we know that better implementation at a domestic level is needed. And further measures need to be taken to ease the barriers, such as sensitisation and appropriate training of the police and legal personnel. States need to deliver justice, not just the black letter law. And the second idea I wanted to leave with us tonight was that humanitarian actors themselves have a role to play, particularly as the basic needs must be met so that survivors are in a better position and able to seek justice. Access to justice is not a one-size-fits-all, we know this, and it's not a solution for everything, and we need to pay really careful attention to factors including gender, however it is defined, ethnicity, disability, religion, migration status, and assess how these issues intersect and shape the needs, often the capacities and the experiences of survivors. And I think we really need to take these factors into account as we move forward. So, ladies and gentlemen, I think it's also important to note we have come a long way in 30 years. Sometimes, I think those of us who've been working on this for many years, you can feel a sense of deep grief and frustration that we're not progressing. But in fact, we have come a long way in 30 years. And whilst we have a long way to go, I also wanted to finish off by paying tribute to very brave individuals, such as the 2 Nobel Peace Prize winners this year, and many others. And in fact, an amazing woman, an Australian woman called Jan Raffa-Hearn, passed away this week in Australia, and she was a survivor of being a comfort woman in World War II. And in fact, she had a huge impact on me personally in speaking out, and her bravery and the impact she had in speaking out on her experiences and trying to seek justice. So I think we need to know we need the energy to move forward. We need ideas. We need to hold on to the fact that we are moving forward. We need to listen very carefully. And we need to make sure that we overcome this issue that is unacceptable and can be overcome. It's an issue we can address. So on this note, I will pass it over to our panellists. Look forward to what they have to say. I'd like to introduce our moderator for the night, Dr. Meg Davis, and she is a senior fellow at the Graduate Institute, and she's also an instructor at the Geneva Centre for Education and Research in Humanitarian Action, often known as CERAH. Mm-hmm. But Meg, take it away, and I wish us all the luck in this journey we're on. Thank you.
I'm just going to say a few words about the course that I teach and about the topic before turning the floor over to these experts. So I teach a course, coordinate a course on sexual violence in conflicts and emergencies for humanitarian program managers. And we emphasize really taking a survivor-centered approach, which includes addressing access to justice as one of the key things that many survivors need. And we've offered the course since 2015. We do it 3 times a year. And some of the participants this time are in the room today, which is great. And then once a year, we organize this public discussion organized by members of the steering committee who advise the course, really aiming to both bring the issue into the public eye, create a space to break the silence and to talk about some of the complexities of addressing and preventing sexual violence, and also creating a meeting space for all of you and for all of us to have a chance to get together and talk and network and learn about what we're doing. So we have drinks here, courtesy of ICRC afterwards, so I hope you'll all stay and take that opportunity. So as you've heard, access to justice is absolutely critical to addressing sexual violence and to ending the climate of impunity that is still widespread, to ending the cycle of violence. And for many survivors, it's part of the process of recovery, or should be in an ideal world. But unfortunately, it's elusive most of the time. And trying to access justice can be harmful for many survivors. And I say this now, I'm speaking now partly as a professional and partly from personal experience. Because in 2002, I was working for an international human rights organization in a foreign country that I'll leave out of the conversation for now. And I was doing research on HIV and human rights in this country, and I survived an attempted rape and an attempted homicide during the course of that work. I reported the case to the police, so I felt empowered in a way that many survivors do not to do that. I was traveling on a US passport, and I approached citizen services at the US Embassy, but the perpetrator was detained and then released. He was never charged. And when I spoke to my friends in this country, local people, I found that several women I knew had had similar experiences, even more harrowing than mine, and most had never reported the crime because they believed it wouldn't be taken seriously. So I'm not here to talk more about that incident tonight, and I'm not here to make this about me, but I do feel that, as you've heard, that survivors who feel that we can survive and can talk about the experience, coming forward to talk about that is critical in order to change this crazy situation in which survivors themselves are blamed for the crime. Personally, I feel that I have no shame for what I experienced. The shame is on the perpetrator, and the shame is on the criminal justice system that failed to hold him accountable. But I'm one of many people who prioritizes access to justice. That's not something that all survivors prioritize. And every survivor's needs are different, and that's why it's really important to consult with the survivor and ask them what they need and not to impose what we think is best for them on them. But for those of us like myself who are human rights activists who feel strongly about a faith in the human rights system, battered as it is, who believe in access to justice, who believe it's essential to upholding the human dignity of all and ensuring non-repetition, access to justice is critical. So in teaching this course, and Tina and Cecile have both participated as teachers in this course, and Tina and I have really wrestled with how to address this with humanitarian program managers because we found a diversity of responses. For some organizations, it's wonderful to hear ICRC say that it's a priority. Some institutions really struggle with how to address access to justice and with feeling that it's not part of the mandate, that addressing access to justice for survivors of sexual violence could jeopardize other life-saving work, could get them kicked out of the country, and so forth. So I hope that us having this conversation tonight gives us a chance to bring the human rights people and the humanitarian people together to talk about how we could be working together more effectively to address this fundamental human right for survivors. So with that, let me introduce our speakers. Just to my left is Professor Cecile Aptel, who's director of the International Federation of Red Cross and Red Crescent Societies Policy, Strategy, and Knowledge Department. She has over 20 years of experience in management, strategy, legal, and policy roles. She's worked at a variety of UN and think tank and NGO institutions, and I first encountered her at the UN High Commissioner for Human Rights office, where she served as senior legal policy advisor and established the UN mechanism on CERAH. She also teaches at a number of institutions, including Harvard University. Claude Maon, just beside her, is legal manager of Médecins Sans Frontières Intersectional Legal Department. And Claude has worked extensively on issues relating to international humanitarian law, protection of patients as victims of violence, and medical legal responsibilities. And prior to joining MSF, she was an attorney at the Brussels Bar and also has worked on human rights issues at UNDP, as well as for Avocats Sans Frontières, Lawyers Without Borders, as well as a variety of other roles. And has a master's degree in law and a master's degree in international humanitarian aid. And Christine Alai, my friend and colleague, is a Kenyan human rights lawyer who's been at the forefront of efforts to obtain justice and reparations for victims and survivors of sexual violence committed during election-related violence in Kenya, both in 2007 to 2008, and then unfortunately again in 2017. Tina was formerly the head of office in Kenya for Physicians for Human Rights, and has also worked at International Center for Transitional Justice, at the Kenyan Human Rights Commission, and numerous other commissions and institutions afterwards. And so over to Professor Aptel.
It's really fantastic to have such a turnout for an event on this topic. In fact, not that long ago, it would really have been something with very few, very committed, but very few people. So it's also really a tribute to how much work has been done, as Helen was indicating. I was asked to present the international legal framework pertaining to the topics that we're discussing. And I can only start by saying that there is a very solid international legal framework now. It's very clear that rape and sexual violence are prohibited in most of their forms under international law. We find prohibition under international humanitarian law in times of armed conflict. We also find a lot of provision of international human rights law that clearly prohibit and ask states to criminalize rape and sexual violence. And we also then have the application through international criminal law. The criminalization and the prohibition that we find under different texts have resulted to individuals being tried for many years now by international tribunals, including the International Criminal Tribunal for the former Yugoslavia, for Rwanda, and the International Criminal Court for committing rape and other forms of sexual violence. So we have a very strong, very, very strong international legal framework. It's also important when we think of rape and sexual violence that we remember that we don't have a single definition of those acts. I mean, we have a definition of rape under the statute of the International Criminal Court, and that's the only one that we find because other treaties do not define rape. But we have a clear sense on the basis of the jurisprudence of the International Court of what rape is about. And it's really about the invasion, and usually it's really defined around body parts, and it involves a form of penetration. When sexual violence is broader and provides for many other forms that may not amount to rape, but that are really prohibited under international law. But what we think of rape and sexual violence also often amounts to torture, for instance. And so we should not be presuming that the words rape and sexual violence can only come under the form of rape and sexual violence. That may also constitute acts of torture. They may constitute other forms of violation of international humanitarian law or international human rights law. And I think it's extremely important that we keep that in mind because, in fact, I was in Bangladesh two and a half weeks ago, and we know that in the context of the violence that led to many people fleeing Myanmar to then seek refuge in Bangladesh, there were a lot of allegations of sexual violence and rape that came out, including many allegations of rape committed against men victims. Yet, in fact, when I was speaking with colleagues there, they say, men say, oh, sexual violence, no, I've not, we suffered much harm, but no, we were not sexually violated, we were not raped. But if you ask them whether they've been tortured, then they will say, oh, yes, we've been tortured, and in fact, my sexual organs were cut. But that they don't see that as being rape or sexual violence. So we need to be very careful, not only in legal terms, but also in terms of using terms that speak to people. And sexual, and the use of the term sexual may, in fact, dissuade many people from recognizing the harm that they have suffered or witnessed. But again, back to the framework, we need to then also recognize that rape and sexual violence may amount to torture. It may also be a form of crimes against humanity and genocide. And we have ample jurisprudence now demonstrating that rape in and of itself can also amount to genocide if it is perpetrated with the intent to destroy in whole or in part a certain specific national, ethnic, racial, or religious group. So we do have a solid legal framework, and there are beautiful documents like the ICRC advisory service has a wonderful fact sheet that you can find on the ICRC website that really give all of the various provisions. So I'm not going to elaborate more on that, but to really turn to then the question of why do we have such a gap between a rather complete international legal framework and then the reality where we see so few cases being really pursued, or not so few, but not enough cases being pursued at the domestic level. And it is because we have a gap between those international norms and standards and then what national legislation say, and then even more of a gap between national laws and their implementation. So really looking at the implementation and turning international legal norms into national laws, we find a number of gaps because while there are obligations by states to implement, domesticate international humanitarian law and also international human rights law, they don't necessarily do it systematically. And that's when differences in the way rape is defined, the limits that may be put around how we understand sexual violence may in fact leave a lot of cases of rape and sexual violence outside of what will be captured under national laws. And then the next step where we lose a lot of cases is because, in fact, while laws may be there even at the national level, it doesn't mean that people and victims and survivors feel that they can indeed use this legal framework. They may be very reluctant to report. They may feel that it is too costly, in financial terms, but also too costly in terms of reputation times. And so there may be many factors that dissuade them from accessing justice. And also the access to justice may be made difficult by a lack of trained member of the prosecution and judges, but especially a lack of training of police and law enforcement. In my own experience in many contexts, that is the crucial point. It's the first time if survivors decide to really seek access to justice, the first entry point with justice will be the law enforcement official. In many countries, the law enforcement official may in fact be a fantastic police person that is really able to do a lot of things, but not necessarily feel very comfortable in dealing with a victim of different forms of violence, a survivor that really comes still very traumatized. And that's really where we face a lot of challenges in the actual enforcement of those domestic legislations that in turn may not be very coherent with what international law really requires. So I think that the problem is not the legal framework, it is the implementation. And I would just like to say one last word, I'm sure we'll be able to come back, that international law not only requires that, not only prohibit and also criminalize certain forms of most of the forms of rape and sexual violence, but it also really gives rights to victims. And among those rights is the right to reparation. And other rights to really, in fact, seek also non-recurrence. And that's really the area that we've not yet sufficiently explored. It's really about how do we move from repression to prevention. And again, we have a very solid framework there, but how we implement it is really key. And my very last word would really be to say that international law, including international humanitarian law, international human rights law, provide for specific protection for certain categories of individuals that include children. It also usually refers to men. But it is really important that we think of the way children are survivors as well in too many contexts of rape and sexual violence, and how we can and should really reinforce systems so that they also have access to justice in a way that is sufficiently protective of them. So many challenges for further discussion.
I also really appreciated that you talked a bit about the issues facing men, because I think that's often an aspect of when we talk about sexual violence, we often forget to talk about male survivors. And I think highlighting that all genders are vulnerable to sexual violence is important.
Before touching this key topic, I would like also maybe to say a few figures about also the work MSF is doing when it comes to sexual violence assistance to victims. So if you take a few years, you can also see the increase that the figures are talking about when we look at that, because since between 2007 until 2018, MSF supported approximately each year 100 projects, and each of them supported approximately 15,000 victims a year. So you can see that in 11 years, it's approximately 180,000 victims of sexual violence that have been supported by our organization. Which is important to note also is that it is increasing, because if you only take the year 2018, it's more than 55,000 victims that have been helped during that only single year. And it means 137 projects in more than 60 countries. So the top three, where we have been the more active when it comes to this specific assistance is, and I would say without surprise on my side at least, the Democratic Republic of Congo, the Central African Republic, and Kenya. But we will also have the opportunity to discuss this, I'm sure. During these figures, amongst these figures also, you could note that depending on the project, of course, between 3 to 10% were male victims. So we were just touching that topic, and yes, this is also a finding that we can make. And a third of all these victims were minors. So when we talk indeed about sexual violence and the work of MSF, we touch also the work indeed of humanitarian organization. And this is not an easy one, because indeed, as we touched already, it's not something that is mandated for a humanitarian organization. MSF is a medical organization, so of course it's not either a protection organization, meaning that our main issue is to treat and care for people. But clearly, the sexual and gender-based violence have been one of the key topics on which the project have increased their answer in the last decades. Among that, this is also noted that since the beginning of the 90s, MSF has clearly starting to provide medical certificates for victims of sexual violence. So it means that it's, you can imagine that with the number of victims that I just quoted, it's a lot of work for people that are not lawyers, that are not all doctors, that some of them are nurses. I mean, it's something that seems like obvious today, but it was not, and it's still not. And it still requires a lot of work, because it means also that we have this systematic policy within Médecins Sans Frontières that each victim of sexual violence will be granted a medical certificate, meaning that it's not even a upon request. It means that we draft it systematically. When we have a victim of SGBV, the policy inside MSF is to systematically draft a medical certificate. It means that the victim can choose to have this medical certificate, and MSF will keep a copy of this medical certificate as well, and will have the responsibility to archive it for the next years. So again, this is not easy. This is a policy. I wish I could tell you this is performed in all our projects, and I am one of the persons trying to make that happen. But of course, it is still challenging, and it happens also that, unfortunately, because of this reason or another, or because of the emergency, because of the mass influx, because of the inability of the staff to do it, it's sometimes not done. But this is the policy, and I think it's quite followed on the field, and that we try to comply the most with this requirement. But the medical certificate, of course, it means, what does that mean also? It means that we have a specific template within Médecins Sans Frontières that we try to use. Of course, we try to discuss it with other actors, and I had some discussion not less than, I think, 3 years ago with your former colleague from Physicians for Human Rights on that question. So the fact is that this can be challenged also on the field by, of course, you imagine a lot of things. The first one being that some countries have already their own medical national template, which can fit or not fit with MSF ethics, MSF requirements, and the medical ethics in general. We can have also issues with the fact that our certificates cannot be recognized by certain courts because of this reason, among others, or because we are being told that our doctors are not allowed to sign medical certificates because they are not national medical doctors that don't belong to the Ministry of Health of the said country. So this can be the kind of situation that we face a lot. We can also face reluctance within our own staff, among others from our national staff, our midwives from the country where we perform the support to the victims, because they might be afraid of the retaliation, they might be afraid also of the consequences of signing these kind of documents. They can be also reluctant to be quoted and to be asked to be witnessing injustice, because they don't want that, because they want to stay hidden, because it's still a taboo, and because also they don't want to be associated with this or with the potential offenders, and so on and so on. So there is also a lot of challenge that we face when it comes to these medical certificates and to their signature by our own staff, or because we are not, as I said, authorized actually to act in such a way. Then we need to be very creative. We need sometimes to ask to other people to sign these medical certificates, and we need to find for medical doctors in the country that will accept to sign the medical certificates for our victims based on the medical file that we can provide them, and so on. So it's really something that can sometimes be complicated. Of course, also we will never force one of our staff to witness injustice if he doesn't want to, because we cannot force people to do that either. So sometimes it also happens that we have a third intervener that will testify injustice on behalf of MSF based on a medical file or on a medical certificate that has been signed by someone else. But again, sometimes we need to be creative. When it comes also to the medical certificate, it's also important to remind, of course, that the medical certificate somehow is a simple document that states the patient's account of what happened to him and of the alleged assault, including all the elements, of course, that may prove relevant, of course, the time, the place, the characteristic of the perpetrator, and so on, as well, of course, as the finding, the medical finding that can be witnessed, but sometimes, of course, there is no medical finding also that can be seen, because you know that we will have, I imagine, the opportunity to discuss that, of course, but after 48 hours of time, it's difficult also to find some real remnants of what can be seen, like there will be no trace anymore of sperm, there will be no trace of other liquid or other, so it's really something quick. So a victim can come sometimes 1 week, sometimes 3 weeks, sometimes 6 months after an event. And on a pure medical perspective, it's not clear that something might be witnessed on a medical perspective, on a medical point of view. So this is complicated for us sometimes, also because in the collective memory or belief, we all imagine that a rape or a sexual offense will be a synonym of violence, will be synonym of trace of violence on the body. And I can tell you, most of the time it's not the case. Most of the time the victim will indeed be probably receiving some violence, but it doesn't mean that there will be trace of it. So it means that even after 3, 4, 5 days, it's sometimes very difficult to find any medical trace of a rape. So it means also that for that, on our medical certificates, we will never refuse a medical certificate, meaning that, again, I stay on what I said in the beginning, we will do it systematically, but we have victims that come after 3 months. We will take, of course, the narrative. There is a part on the certificate that will touch the narrative also of the potential accompanying person that is with the minor in that case, or even an adult that come with someone. And then, of course, we will quote and we will really use the bracket and use the wording and the vocabulary of the patient to be clear about what he said he has been living. But most of the time we are, of course, not the one that can, not most of the time, never be the one that can say whether there is a rape or there is no rape. And this is clearly something that is always asked by the magistrate in justice in the majority of the countries where we are intervening. Was there a rape or was there no rape? And this is clearly not to a medical organization to answer that. So this is a qualification by a judge, and this is for further discussion. Just a few words to finish on the responsibility of course, the fact of a victim acting to justice. This is, of course, not the role of MSF either. So, I mean, we will provide a medical certificate, and we will most of the time try to explain the victim where she can go if she wants to act to go to justice, and to then refer her to a legal aid organization, for example. But what is very key for us is to understand that for us what is key and will always be the followed rule is the consent of the patient. So nothing is done which is not based on the consent of the patient. And the second key word for us, of course, is the respect of medical confidentiality. So those are the two key points on where we build all the support that we give to the victims. And in case she goes to justice, it will be her choice and it will be her move. Of course, we can be supportive, but we will always act by those two principles.
Thank you very much to the organizers for inviting us to share our experiences from Kenya. So 12 years ago, as many of you may know, we experienced widespread violence following our contested presidential election. It wasn't the first time we were contesting election outcomes, but it was the most widespread form of violence that we had witnessed in a long time that affected 6 out of 8 provinces in Kenya and resulted in numerous atrocities, including at least 900 documented cases of sexual violence, mostly against women and girls, but also men and boys. For the past 12, almost 13 years, because this was December 2007 to February 2008, my colleagues and I have been through a journey of supporting survivors of sexual violence as well as other forms of atrocities to pursue justice. As we speak, as far as I know, and we have challenged the state to inform us if our facts are wrong, there isn't a single one perpetrator who has been held accountable for election-related sexual violence. As far as we know, not one survivor has reported to us that they have received reparation. So there are numerous things to say about this journey, but I'd just like to focus my attention on why survivors of sexual violence have been left out and what their experiences have been in subsequent court proceedings that I'll speak about shortly. So in the preliminary phase, I'll just take a few minutes to speak about that. The first defense that we have had from the state is that although there are survivors who reported, they speak about at least 300 documented cases within the Office of the Director of Public Prosecutions and Office of the Attorney General and Police. They state that survivors are unable to identify their perpetrators. and therefore the hands of the state are tied with regard to pursuing accountability. The second issue that has come forward is majority of the survivors that are reported in an official report, the Commission of Inquiry into the Post-Election Violence, which has the statistics of 900 survivors. And this 900 survivors only represent a small percentage of survivors who are able to make it to health facilities within 72 hours of the occurrence of their violations. Physicians for Human Rights subsequently did a study between 2013 and 2014 that actually revealed that over 20% of survivors within the court system, within the health facility system in 3 health facilities had come almost 1 month after the violations occurred. So this data does suggest and confirm that many more survivors, aside from the 900, were actually unable to come forward. So before survivors even get to the access to the justice system, they face numerous barriers that make them unable to report. And subsequently, and this is where I will focus most of my attention, they continue to face that discrimination in the justice system. So, as you may know, in 2010, after the government of Kenya failed to set up a special tribunal to prosecute not just sexual violence cases, but also police shooting, extrajudicial killings, amongst other violations, the prosecutor of the International Criminal Court, for the first time, used his proprio motu powers to initiate charges in 2 cases before the International Criminal Court. As we speak, the 2 cases were withdrawn, so there are no criminal proceedings, either at the International Criminal Court or domestically. But at the time, 2010, whereas the ICC had instituted proceedings, there were still significant impunity gaps. The most glaring was that the cases only focused on individuals who bore the highest level of responsibility, as the Rome Statute regime requires, meaning you had numerous other direct low-level perpetrators as well as mid-level perpetrators who did not have an avenue for accountability. But secondly, the cases only focused on violations committed in very small locations, particularly rape that was committed in Naivasha and Nakuru, leaving out, for example, forced circumcision against male survivors that also occurred. And so civil society organizations, including Physicians for Human Rights, the Kenya Independent Medical Legal Unit, Coalition on Violence Against Women, and International Commission of Jurists Kenya instituted a case. And so this is the only case we can speak about today that focuses on accountability for 207 to 208 election-related sexual violence. It is not a criminal case. It's actually a constitutional petition that seeks to hold the government of Kenya accountable for its failure to fulfill human rights obligations to do 4 things. 1, we assert that the state failed to prevent the violence in the first place. Secondly, they failed to provide protection measures, including medical care, psychosocial support, and other protection measures for victims. Thirdly, that the state failed to institute genuine investigations and prosecutions that could lead to prosecution not only of direct perpetrators, but also of commanders, also of those who facilitated or organized those crimes. And finally, that the state has to date failed not just to provide reparation, but even to recognize, even to acknowledge that survivors of sexual violence exist. And this is, for example, if you wanted to directly compare, over 600,000 displaced victims have received some form of assistance. It doesn't amount to reparation, but they've received amounts ranging from $100 to $1,000, some cases $4,000 for resettlement, buying land. There has been formal recognition, a ministry, a special program for displaced persons, but not for sexual violence victims. Some children were born from the rape. They have now turned 11 years, and the state continues to fail to acknowledge. So we are in court, and I'd just like to mention 3 things that stand out with regards to the discrimination, again, perpetuated in the justice system. First and foremost, the lack of capacity within the courts but also by judicial officers, prosecutors, in having a nuanced understanding of the manner in which sexual violence manifests itself and the manner in which the consequences are experienced by victims. So issues such as badgering of witnesses who have taken the stand in this constitutional petition, issues such as security, re-traumatization, the kind of defense taken by the state that continues to ask, how would you expect us to know that you were violated if you did not report? How would you expect us to know what kind of reparative measures you need if we don't know that you exist? So the state, in its totality, has demonstrated its lack of nuanced understanding on the differences that sexual violence present compared to police shooting or torture that are evidently manifest and the types of evidence that are required. Security issues. So we now have just 8 victims in the case representing thousands of others. Many others are left out of the proceedings, and one of the most significant challenges that the victims expressed to us was the fear of reprisals. 3 out of the 6 female survivors were gang raped by state security officers. So the question was, what happens if I cannot be offered security? And we had to think very creatively. One of the things we did was to ask for a court order to redact the identity of the victims in court proceedings. This is a usual measure. However, much more could possibly have been done, provided within legal or policy frameworks, but also infrastructure. So for those of you who may be familiar, and this must be the case with many developed countries, if you walk into a courtroom, it's as open as this. The ICC has fancy measures like a board that will cover or distort my voice, but for our survivors, you have to walk into a courtroom and without being creative about how we protect your identity, then you are potentially targeted for reprisal. So what we have done, again, to be creative, is every time we have a hearing, we come into court with a hive of 50 to 100 other victims who then have to camouflage the identity of the 8 victims. Thirdly, length of proceedings. We filed this case in February 2013. To date, we're still in court. How many judges down the road? 5. Are we going to get justice? The one judge who listened to the 8 survivors present their testimonies has since been promoted to the Supreme Court. Subsequently, we have had 4 judges. The latest is now on a list to be nominated to the Court of Appeal. And so survivors are disillusioned. And finally, psychosocial support and economic assistance. Many institutions, such as Physicians for Human Rights and the other CSOs that support survivors to bring justice, do not have a mandate to provide psychological care, income-generating support, but survivors get wary along the way because we cannot promise them continuous psychosocial support. We cannot promise them school fees for their children. We cannot promise them health care. And so in the absence of a deliberate consideration by the state and the political will to actually recognize and provide the kind of rehabilitation that survivors need, then access to justice becomes a really huge challenge. I hope that we can have more time to share other aspects, including how do survivors define justice? It's not just the punishment of the perpetrator. Do justice mechanisms provide rehabilitation? Do courts make orders for structural reforms that can actually guarantee non-recurrence of these violations?
I wondered if we could just spend a moment reflecting on what humanitarian organizations can do without jeopardizing their other work. And of course, we've been hearing about the medical certificates, which I think MSF is one of the few international organizations that provides that service. Tina, I'm going to put you on the spot as my friend for many years now and ask you to start, because I know we've talked about this a lot. So what are some things that humanitarian organizations could be doing?
I would like to start by just acknowledging that while we've reflected on this question, we appreciate that every institution, every sector comes with a specific mandate. And humanitarian institutions do have specific mandates in different contexts. However, where the challenge is the lack of deliberateness to own the acceptance. ICRC has policies and so on. MSF is providing medical certificates. But do we situate the roles that we carry out within the access to justice stream? And if we could do that more, then we would have better collaboration with other actors who have a more prominent role in supporting access to justice. How does MSF, for example, link with humanitarian actors, you know, after it's conducted its medical certification, and so on? So how does ICRC, for example, while maintaining its mandate, that does not go out as the human rights sector does, as Human Rights Watch does, to, you know, bash the state and demand, can we see justice? How do you work collaboratively? I think the challenge that we're experiencing is humanitarian institutions are often the fast responders. In Kenya, it's a different context because whereas we had conflict, it wasn't comparable to Syria, for example, where you have a total breakdown of institutions. But in some contexts, humanitarian institutions are the only form of intervention that can provide medical care, have a repository of documentation that then provides a basis for access to justice in the future. And so, in summary, I feel that perhaps where improvements could be done is not to shift the mandate of humanitarian institutions, but to have a more deliberate and nuanced understanding of how their different roles and functions that they carry out every day, medical certification, engagement with state actors, and so on, protection, psychosocial support, can then be used to support survivors to access justice along the justice stream.
I cannot agree more. So I think it's indeed it's crucial. The problem is that I think also that from a perspective where, and I think I can speak also for myself because I am a lawyer, having worked as a lawyer before. I work now for MSF as a humanitarian worker, but I've been also working for a legal aid organization. I worked for 5 years in a fight against impunity in Africa. So I mean, I belong to the other side also sometimes, where I need also to make understand to the people that they are repository of a huge, massive source of information. But we don't have to forget also that each organization has also its specialty. And I can tell you that there is not a lot of lawyers within MSF. So it's really an organization of doctors, and it's an organization of people that also focus on the care of people. And as one of the few lawyers within MSF that is also now able to have a team working on things like this, I mean, this is also where you see that it is evolving. So we have now people working specifically within MSF on medical legal issues that are trained also to analyze what are the legal framework in the countries of intervention on rape, on sexual violence, that are briefing the teams on what it means, that we are briefing the teams on how to fulfill medical certificates. We are archiving the certificates, come back to us, and we archive them ourselves. So I mean, there is clearly a conscience more and more around this. And I can tell you also as an example that 2 months ago I was in Bangui and I trained myself for 2 hours the magistrates of the court in Bangui to explain how works our medical certificate, how they should accept it, how they can understand the terminology that is framed under this medical certificate. I brought some doctors with me in order for them to speak the question, and I can tell you this is not common, this is new. But this is also because we are working on that, and I strongly believe that. But it's not easy, and it's also clear that we don't have to forget also that MSF is an organization that is able to go in places where no one goes, except probably ICRC, and where no one else will go. And this is also because we are neutral, because we are independent, because we are impartial, and because the states know that we are allowed to go there. And if the main thing that we do is witnessing at the ICC for the violence that the people are witnessing, unfortunately, the consequence of this will be that indeed we will no longer access these places. So we are not ICRC, and we speak out, and we are not either Amnesty International nor Human Rights Watch. We are Médecins Sans Frontières, and and we are doing our best, but clearly I feel that there is more and more this conscious of that, and we are, I mean, clearly pushing the teams when we are traveling on the mission also to make them understand that they need to collaborate much more with the protection actors, with the legal aid organization in town and so on. And this is something that is more and more taking another dimension. You will see much more often Médecins Sans Frontières participate in the protection cluster now that you would have seen 5 years ago, for example. So I think it's really something that taking that direction.
I see that as very much a complementarity. Really, there is a role for all of the various categories of actors. And it's really key to look at the full spectrum and at each actor really playing its role. I think that really looking specific, so complementarity between what human rights actors, prosecutors, human rights lawyers, medical personnel, other types of humanitarian workers can do, it's a full spectrum. So one doesn't exclude the other, but really it's much more about how can we all really work together to really also address the very varied demand of survivors. I mean, we can't, and we know that in fact, it is also absolutely critical to hear individual survivors to really see what their own demands and needs are. And we know that not all of them not all of them have the same understanding of justice. And so when we really think of access to justice, what does it really mean? And for some people, it means, first and foremost, I want to stop suffering and not being able to actually go outside because I keep bleeding all the time. For others, it may be, I really want to make sure that I can still, in fact, I mean, an experience that I had once in the Democratic Republic of the Congo was really a lady saying, for me, access to justice is being able to go with my daughter to the market in the neighboring little town so that we can sell our vegetables without having to go in front of the police station where I see the policeman that raped my daughter. And her having to actually walk in front of him, often having a little sarcastic laugh. And so that's also a form of justice that is more linked with then non-recurrent. So they reach such a large spectrum. One thing that we have not yet said in terms of humanitarian actors is working in full respect of the do no harm principle and making sure that humanitarian actors themselves are not causing any form of sexual violence. And I mean, that's really something where there's been a lot of progress, and I think that all humanitarian organizations have been seeking to really just ensure that we have measures in place to really prevent, train people, and have measures in place in case any allegations is raised and there are occurrences. But it's also true for all of the other categories of actors. And I also want to insist on something which is as part of the movement of the Red Cross and Red Crescent. I mean, there is also a huge amount of work that is being done in working with armed actors. And so the ICRC, for instance, really work extensively with armed actors, including armed forces and the police, in also training them. So that's also a crucial humanitarian role that can be played. So again, just insisting on the complementarity and you know, everyone playing their own roles as best as they can.
Maybe, Meg, I think you said something very important, which is what is actually justice. And without entering into anthropological or very deep sociological finding, I remember an experience I had in the Gambela region in Ethiopia at the border with South Sudan, where I was conducting a little survey at that time for UNHCR, where we were trying actually to understand more how we could help them accessing justice in the camps. And I was with a translator, and I was trying to have a few questions answered. And I don't exactly remember the question I asked him, but it had the word justice in the question. And he really looked at me and he said, "I don't understand your question." And so I repeated it, like, let's imagine it was how could we bring justice? What do they need? And he was really like, I don't understand. So I tried to explain and with another vocabulary. And then he said, oh, okay, I think I see. And then he started discussing with them. And he was constantly referring to me saying, they don't understand, they don't understand. And he tried 5 or 6 words, like a synonym with peace or with other, and nobody understood. And so clearly, I at the end, I said, okay, for them, what is it to live in peace? and to have the impression that their needs are respected and they don't fight and they don't. And he was like, yeah, but this is peace. For the rest, we don't care. I mean, as long as and actually they had no sense of what justice was for us or in our Western perspective, and it was really important, I think, to remind, because I mean, at the end of the day, this is also sometimes very, very Western also for us, because what it means also sometimes is we all, I mean, a lot of victims actually are not willing to go to justice. A big majority of them are in what we see on a common base. It doesn't mean it's for the good reason. Huh? It maybe means that they would like to go, but they are facing too much challenges and they prefer not to do it. But this is also something we need to ask ourselves sometimes, because we all want to go to justice and we all want them to go to justice. And I'm sure, of course, a lot of them want also to go for justice, but a lot of others, the question is asked, and I think sometimes we also need to realize that.
I think we also have to address the fact that the lack of resources globally for work on access to justice, because none of the organizations that are doing any of this work have enough funding to do everything that needs to be done. But I think the human rights organizations that are providing access to justice are at perhaps the greatest disadvantage. They're often domestic NGOs. There's very limited international funding. If you accept international funding, in some countries you're then branded as a foreign agent that's working for some foreign agenda. And so I think there's a real question about how can we create greater solidarity for those who are on the front lines of doing the kind of work that Tina's just described, advocating for those who do want justice through the court system, acknowledging that that's not what everybody wants.
Just wanted to echo the issue of complementarity, and what what I'm referring to as deliberateness is the appreciation that each of the different roles we play can either jeopardize or enhance the prospects of survivors accessing justice. So whereas humanitarian actors have a specific role, oftentimes it's protection, it's healthcare, and human rights actors are on the other end. In the absence of thinking about that mandate as potentially affecting access to justice, then we end up affecting the prospect of survivors to access justice. And the deliberateness then requires MSF, for example, to have an introspection that, and I use MSF because I'm much more familiar with medical evidence and forensic documentation. How do we conduct our mandate and functions in business in a way that will protect survivors' opportunities to access justice? It's not how do we change our mandate so that we can fit into the access to justice debate, but it's really we continue to do what we do in a way that will safeguard the opportunities to access justice. And of course, there are limitations on all ends. There are limitations in the human rights sector, in the criminal justice sector, in the humanitarian sector. And that's how come collaboration then becomes critical. But we each have to appreciate that as part of that survivor-centered holistic approach, protection, healthcare, psychosocial support, all are part of the web that then leads to support to access to justice.
All right, on that note of collaboration, let's open the floor up to all of you, because I'm sure there are people here who have questions or reactions to what's been said so far. So any hands? I see a hand in the back.
Yes, my name is Mamadi from UNAID. I think I was extremely interested while hearing 2 or 3 key points that need to be quite really fully taken, into account. One, whenever we talk about sexual violence, there is one parameter that seems to be quite really overlooked. It's how are we going to address the young boys' situations. I think that's something extremely important today. I have been going in different places whereby that particular aspect seems to be quite really neglected. Secondly, I also recall that, part of the difficulties that we might be having in order to quite really address justice to the victims might be quite really connected to the fact that there is not a systematized approach in collecting very accurate and factual data. That's something quite really missing. Perhaps, I mean, we have to quite really generate a new system of collecting data that might be extremely relevant to those who are quite really involved in making judicial proceedings. The third aspect, which seems to be also very much critical, is the linkage between sexual violence and HIV prevalence. I have been in some countries where myself, after a war breaking, there have been thousands of women being raped, and some years back, having a high prevalence of HIV transmissions. By the way, there is even a Security Council resolutions that quite clearly stipulate the linkage between sexual violence in conflict versus the HIV prevalence. So how are we going to correctly address that need in our collective effort in the end might be something extremely important too. And let me conclude now about the overall challenge that we have in concerning the advocacy, the capacity building, which in the end can be seen as the major obstacle in order to correctly address fully justice to the survivor.
My name is Liz Macharia, and I'm from the University of Botswana. Thank you very much for your very insightful comments on this issue. I wanted to highlight what I think is a really important issue, which is one of education on all levels on the question of sexual violence, particularly on our continent in Africa. The reason why women do not report sexual violence is that they're shamed at every level. In the home, in the courts, in police stations. It's a matter that is kept private and hidden, and these are cultural issues. And I think there's a real important matter that has to be dealt with, which is bringing what is in the dark into the light. There's a need to make women more comfortable in reporting sexual violence in the spaces where they are, in the homes, in the courts, in police stations. I'm speaking about women in particular. I didn't mention men. Women don't report. Men would probably never report on the continent. So I think it's really important, if we're going to talk about access to justice, to make sure that we educate in the schools. We have to educate in the courts, our judges, our magistrates. We have to educate our police officers. Somebody mentioned people laughing and sniggering at victims, knowing very well that if they report, nothing will be done. So your work is wonderful, but there really is a need to connect to communities on the ground in the criminal justice sector in order that things should actually change.
Awareness is key. The only problem is that clearly this can come only also with the fact that the perpetrator would stay still, because even if you keep going in the communities and make awareness session and so on, people will start more and more to talk about it, but they will still fear the retaliation. So this is really something that is complicated, and to me this is also touching the question when we come to justice about the protection of witness, which is really something we didn't touch tonight, but which to me is one of the key problems when it comes to access to justice, and this touch in all the sectors. Should it be national, international justice? Should it be the fear to come to MSF or to any other organization to seek for legal, to seek for medical care, for legal, for anything? There is the fear of reprisal and retaliation. And even if we talk about education and awareness session in the communities, this is also there. So I mean, to me, there is really a problem when it comes to the protection of people who talk, because this will stay. And this is true since the last 10 years where I'm working on this area. And this is not enough brought to knowledge, because when we easily say people should talk, people should go to justice, one of the main issues is the protection of victims and the protection of the witness of who can help these victims to get access to justice, and this is a massive and main issue, and it's of course super complicated because it also demands a lot of money and a lot of financial means in order to be able to put in place systems of protection, to put in place some shelters, to put in place some relocation mechanism, to put in place all these support, without which I think access to justice will honestly keep being compromised and jeopardized.
Both set of questions go to a fundamental issue, which is societal perceptions of really what is it to be a woman, what is it to be a man as well. Because in terms of boys, I mean, the challenges that we find across cultures is really one of stigmatizations that may even be more important for boys and men than it is for girls and women. And it comes with an image or an understanding of masculinity. And in fact, also, Liz, I mean, really, it comes with then the question of what is the role of a woman. And what we see across culture is that through the shaming of a woman, it's also often, in fact, the shaming of a family with the understanding that, in fact, a woman or girls belong to a family, belong to a community, and attacking her is, in fact, attacking her community. Which is why then in many contexts, armed conflict or others, we really have situations of massive or systematic rape that have been used as, it's been called a weapon of war by the Security Council. It's also really when we find crimes against humanity or genocide, so systematic war crimes that really, where then it's not about attacking individual victims, but it's really attacking their communities. And that is only possible when, in fact, there is the understanding that through the body of that woman or that boy, in fact, it's attacking the community. I'm always puzzled in looking at all of the various situations where we had systematic rape, that the children born out of those rapes are deemed to carry out the identity of their biological father. That's true from the Janjaweed in the Sudan to Darfur to Bosnia-Herzegovina, where in fact, so you know, looking at Africa and Europe across different cultures, we still live in a world where very often the identity of a child in those contexts is deemed to be directly and without question the ethnic or religious identity of his biological father who raped his mother, which really, in fact, is denying the mother her own identity. Yes, I mean, if she was of another religion or another identity and she's deemed to have been giving birth to a baby that belongs to the other religion or other ethnicity, it basically denies her own identity. And that's so significant of very deep cultural understanding that we have of women as in fact not carrying the identity, because we live in patriarchal society, I mean, almost everywhere in the world. And so we can't deny that, in fact, rape and sexual violence is also taking place within this context. And unless we interrogate those ideas of what it means to be a woman and what masculinity is about, we can't really defeat some of these issues. So it's absolutely true, and that's why education has such an important role to play in really unpacking this and helping us to really also, and helping the survivors in particular, to really understand that it's not about an individual shame, and therefore helping them to really restore their dignity is absolutely crucial. Another thought that came to my mind listening to both of you is about the reporting. Because in fact, the police is, again, I mean, for those survivors that decide that they want to have access to justice, understood as access to court and some form of conviction, penal repression, criminal repression, they first and foremost need to be able to report to the police, usually, in most legal systems around the world. And that entry point to the law enforcement system is one where we don't have much protection. I mean, at this stage, they can't go with, you know, many people, other survivors around them. It really is very stigmatizing, and it takes a lot of capacity. You were referring to your own case. I mean, really a lot of you know, knowing that you're not going to be first and foremost physically attacked again, knowing that you're not going to be psychologically embarrassed or harassed or traumatized, knowing that then you're not going to be beaten up again, and that comes to the physical security by the police, in the police station, or when you exit by a mob, or when you return home by your own family. And then it also means having often the money to be able to even go to the police station and sometimes pay the fee that you may need to pay before you report. So there's so many actual, very minor impediments that are there, but also, again, deeply rooted challenges that survivors face in even going and reporting to the police, that it's not surprising at all that we've got such a low rate of reporting. Because frankly, we're asking them to really go and expose themselves in many contexts at the risk of being re-traumatized, if not, in fact, beaten up. And so how do we, unless we really just unpack all of this, it's really difficult to then really think of access to justice despite everything else that we may be trying to do for survivors.
I think it's absolutely true that it's very, very difficult for most people to report the crime. And for that reason, we have to, and Mamadi, I'm glad you raised the point about data, we have to be very skeptical about any numbers we see and assume that they are an underestimate. And I know that ICRC has this great policy of requiring reverse burden of proof, right? So that you don't wait for numbers and prevalence studies to decide, yes, sexual violence is happening. You put the program in place first, right? And I think that's very important because, as we talked about in our class a lot, especially on the first day, there tends to be this pressure to produce data, right? Because otherwise it's, like the aphorism goes, absence of evidence is taken as evidence of absence, right? So that the fact that there's no data means that therefore it didn't happen. And so we just passively waited for people to come in and report. They didn't report, therefore it didn't happen. And we have to be really careful about that with sexual violence because most people do not report. But that said, it is possible to elicit disclosure, including from men and including in Africa. So we have a Refugee Law Project as one example of very important work that's been done to create safe spaces in which men do disclose that they're survivors of sexual violence, conflict-related violence, and then also become activists and speak, including, I think, at the UN quite recently, about their experiences. So with the right program, with the right trust, it is possible to elicit disclosure. So I don't want to end up in a too hopeless of a place in regards to the data and disclosures. Maybe we'll take another round of questions. Please, over here.
My name is Brilliant Kisboles. I'm a student of the University of St. Gallen, and actually what really came to me as an interesting point is the accountability. There's been a mention that at the end of the day, people who even report don't even get justice. The judges change, and the fact that in Kenya there's been no judgment of anyone being raped, and this justice is actually missing. And my question is whether we should actually make government accountable for not putting the sufficient justice framework for these people, and if we should, then who could actually put pressure on governments to create this legal framework and say that yes, it is a shame that after 10 years, not even one person was able to get this, to get justice.
My name is John Wamwara. I'm from Kenya. Except for an unnamed African country, then there is Kenya.
Oh, it wasn't African, but please go ahead.
Some unnamed country plus Kenya, DRC Congo, South Sudan, Ethiopia. There's this impression that sexual violence, access to justice is a challenge in Africa. Probably could you, in your work, tell us a little bit about these challenges that may be in other parts of Africa as well, other parts of the world as well?
Hi, my name is Abigail. I'm with UN Office for the High Commissioner for Human Rights. So thank you, first off, for speaking with us today. You've already established that there's well-founded and strong international legal framework surrounding sexual violence within conflict, but I work a lot with access to justice for migrants or refugees or asylum seekers who are in transit. And there's, so going back to your point, so I work with the Americas, so we're seeing sexual violence against migrants coming from Central America up through Mexico to the United States. Venezuela, there's a huge problem with refugees seeking asylum in other countries and falling victim to human trafficking or sexual violence along the way. So if you could talk a little bit about what are some of the options or some of the legal remedies for victims of sexual violence, where there are victims of sexual violence as a result of conflict, but not directly within the conflict. Thank you.
First, I think just to say that what the conversation, or rather where this conversation leads us, is that access to justice for sexual violence, unlike other forms of violations, is actually a collective challenge. It's not just states. The reason why survivors experience stigma is not because the state stigmatizes them in the first place. It's because you and I stigmatize them. It's because their families stigmatize them. The reason why men will not come forward is because they fear you and I before they even fear the police officer who's going to be at the reporting desk. And so I often ask the question, if today you left the room and went home and suddenly realized that while you were keenly listening to the panel discussions, somebody went into your purse and stole your wallet, or your expensive latest iPhone, I don't know, where are we now? iPhone what? 10? What's your immediate reaction? It's an injustice, and I want to report. I want justice, right? Particularly if it was quite expensive. If it was cheap, like some of the phones in Kenya we call kabambe, $10, and it doesn't really cost, we'll be like, okay, well, the trouble to go through the justice system is much more expensive than going to buy another phone. But when you're seriously violated, there's no two questions about it. You want justice, and you will take the necessary steps. You will do whatever you can, and the system is often waiting for you. So I just want to underscore the fact that there are challenges to access to justice for many other forms of violations, for many other forms of crimes. Even as I speak about the experiences of post-election violence, there are still victims of police shooting, of other forms of violations waiting. But in my experience and observation, in our experience and observation, why sexual violence stands out and stands apart is because of the socio-cultural factors. And until we can dismantle them, until we can shift our attitudes, until we can accept that this is a collective challenge, despite the beautiful advancements in the laws and the policies and the international and legal framework, beautiful courtrooms at the International Criminal Court, we will still continue to face the challenge of access to justice for sexual violence. And so education is critical, but I want to flip this to challenge each of us that it actually starts with you and I. And we need to undo the socialization that we have embraced, the patriarchal, morality, honor, purity, property, and begin to think of sexual violence as a human rights violation, as a crime that requires as much investment, as much deliberateness. We teach about HIV, don't we? When we talk about education, school curriculum, training, capacity building of prosecutors and judges, we are not unaware of what we need to do as states and individuals and duty bearers. But because we come into the system from our communities, our families, our societies, and then perpetuate these negative attitudes into the system, if your father and my father is the police officer, why wouldn't he ask a survivor the questions that police officers ask? And that's what we have to challenge ourselves about. It's a collective challenge. And until we uproot that negative discrimination and socialization, victims and survivors of sexual violence, not of police shooting, not of theft, will continue to experience barriers and challenges to access justice.
Sexual violence is certainly not a special gift for Africa, certainly not. There is, of course, we know all over the world, and I would like just to tell you an anecdote where we are actually on the European soil. So this is my continent, right? It's not yours. And we are clearly also facing a lot of issues that are exactly similar. So this would be an MSF project with a victim that was raped the same day by 4 men of our community. She decided to report this case. I happened to be on that project that day. So it's a project that is run in Europe because since what we call the migration crisis, which is really a definition I hate. But then we have within MSF programs in a lot of countries in Europe. And this lady decided to report the case the same day. So I happened to be there. I spent 6 hours with her in the hospital. And the police and the forensic doctor who came decided to interview her and to make the medical examination. And they were 2 policemen, the forensic doctor and the translator. So you can count the same way I am doing. It makes 4 men and 4 persons. And this lady was reporting a story of a gang rape the same day involving 4 men. And I swear to God, I almost fought with this guy because I was so upset. And I was like talking to these people telling, do you see something in interviewing and making a medical examination with 4 men? And the story she's telling you. And this is crazy. And this is a year ago on the European soil. So I can tell you that absolutely we are facing all the same challenges. And there is certainly no exception to the impossibility for people, and it seems so obvious, so incredible to come with supporting victims of sexual violence with such an answer that I can tell you I was probably more shocked by this than by anecdote that I learned from previous mission in Africa or elsewhere. So.
Just on that last point, I mean, I was referring in my earlier intervention to children born out of rape in Bosnia-Herzegovina, so at the heart of Europe. And the next questions being about migrants, I mean, that's really something that again also affect all continents. And so unfortunately, yes, the very deep cultural bias that come with patriarchal society is really shared everywhere in the world. I think that only very few cultures in isolated places where we don't have very strong patriarchal understanding of societies. That is really what really underpin what you were mentioning earlier. On migrants, maybe let me just step back to say that so we have those international standards and norms and provisions that include those in conflict under international humanitarian law and also outside of conflict with international human rights law. But then the reality of where a survivor can go and seek remedy, where a survivor can go and report a crime to the police is within one given country with domestic legislations applying. And so that is why then migrants that may have been raped in one country that they have left, and in the meantime they have been transiting or are transiting through other countries, may really face serious challenges in reporting crimes that they have suffered in other countries by nationals of another country. For those acts that will amount to torture, we have a convention on torture that actually really provides for the principle of universal jurisdiction. So in theory, an act of rape that will amount to torture, for instance, or an act of rape that will be a war crime may ideally lead to any court anywhere in the world saying, yes, we're going to investigate that allegation and we're going to try those responsible. That's the idea of the principle of universal jurisdiction. In reality, there are very few countries that have really a jurisdiction or given jurisdiction to their court to really do that. And in any case, and more importantly, people that are migrants, to really come back to your question, Abigail, people that are migrants may often be undocumented, illegal, and may really not want to be exposed. And they fear that reporting crimes that they have suffered may therefore expose them as being illegal migrants and undermine their capacity to then continue on their migration route. I've actually even seen it in the context of people that are illegal undocumented, in fact, in the country and may have been in the country for a really long time. And I'm thinking in particular of, for instance, domestic workers that may be illegally in one country and be systematically raped by their employer and really face that, find that they don't really want and report, because the minute they report those crimes, they're going to be having the police turn to them and said, show me your work permit, okay, you're now expelled from the country, and that may really subject them to much more harm. So we really face challenges with those issues of, in fact, those international laws, as developed as they may be, are only as good as what domestic law enforcement officials can really do within the constraints of their own domestic national legislations.
I feel that we've barely scraped the surface of these really rich and complex issues, but I think that we've at least put them on the table, which is a good start. I think there are not enough opportunities to talk about these specific challenges. And I think, just getting back to this question about, is it a problem of a culture or of many cultures? I'm an anthropologist, so I think that we have to be very nuanced how we think about the culture issue. And there's a lot of research now, Elizabeth Wood and others, looking at specific contexts and finding that there's often asymmetry within one culture, within one country, in sexual violence. It's not always everyone in the context of a conflict who engages in sexual violence. There can be real significant differences between organizations and armed groups in how they view and address this issue. And that means that it's not always about culture, that it could be more the culture of the organization or of the armed group than the country. And that means that it's fixable, because organizational cultures can be changed. And with all of the challenges we've talked about, with all of the issues we've put on the table, as you've pointed out, this is a fundamental human rights issue. It's clear, the international laws are clear, and so we all just have to get better at addressing the rights of survivors. So by working together, hopefully we can do it. I think we are almost ready for a drink after this discussion. I know I certainly am, but not without a few parting words of wisdom from our esteemed advisor, Joanina Karugava, who is the Senior SGBV Advisor at UN High Commissioner for Refugees.
Wow. A collective challenge. Justice denied. Justice compromised. Justice jeopardized. It's fixable. I could go on and on. I'm sure you've captured what you've captured. But the discussion could go on late into the night, and it could take several days. But we're shy of 90 minutes, and the 90 minutes we allocated. So we come to the end of the discussion, but not the end of the issues. So, on behalf of UNHCR and on behalf of the advisory group to the CERAH course, I would like to thank the panelists, thank you very much, and the moderator, thank you, Sarah, for enabling us in this short time to have a discussion, to grasp challenges that span decades backwards, but also that continue to haunt us, probably in the future, in the foreseeable future, but also enabling us to capture the opportunities that exist, also to capture the developments which are happening within the legal framework, but also in different initiatives being taken by different organizations. It also helped us to understand the different populations, whether in a development context, whether migrants, refugees, asylum seekers, different contexts where people face the different challenges. So that was, in a short time frame, we've really tried to cover a number of issues, which we appreciate. There are other developments that all of you could probably contribute and say, my agency is doing this, people are doing this. And it's an opportunity to highlight that the coordination mechanism called the Gender-Based Violence Area of Responsibility, one of the global coordination mechanisms for internal displacement, focusing on gender-based violence, is coming out with minimum standards for addressing gender-based violence in humanitarian situations. And they've included a chapter on access to justice. It wasn't an automatic thought, because initially people said, maybe it's not urgent, maybe it's not a minimum standard, but it's there, meaning we're making progress, small but contributions. one of the things which came up towards the end is that it's evident that there are resource requirements, laws needed, remedies and effective, lots of things that are needed. But one of the things which came up was the need for the change in attitudes. Change in attitudes at the individual level, but which also influence populations and nations and hold us in bondage. The bondage of denial of justice, justice for survivors of sexual violence. Unlike other forms of injustices, injustices for survivors of sexual violence. But we know it is not inevitable that people can access justice. It is possible. This is just one of many humble contributions to raise the voices and to build the momentum required to create a shift in the landscape on access to justice. There was a call for more deliberate and nuanced action by the different entities, whether it's in humanitarian or in development, and how to bring those two areas, the nexus between humanitarian and development, together. Every voice counts, and every action counts if it is focused in the right direction of addressing access to justice for survivors. I therefore thank you all, you, the audience, the participants, the students who are in the CERAH course, but many of you from your different organizations and different walks of life. Interestingly, it was very clear that it's not only lawyers that are behind it, but mental health professionals, anthropologists, lots of people from different walks of life, budding young professionals that have to be part of this journey on access to justice. So we're all there and have a long way to go, but making progressive steps. I would also like to thank the ICRC, sorry about that, the ICRC for hosting this event. They've hosted one before, organized again by CERAH. So I thank CERAH again for continuing to host these events, create forums where these voices can be raised. And opening this event to different people from different organizations, different walks of life, it's really an open invitation because you could walk in without the normal, bring your ID, who are you, and all that. So that's really a welcome invitation to such events and acknowledgement that many people count in this discussion. I would also like to thank somebody who's been part of this journey of the CERAH course, but also personally invested and committed to addressing sexual violence in conflict, but also working in the humanitarian space, Professor Doris Schofer. She will be retiring, but no, it's not a retirement from her commitment. We know that. But thank you so much for all your contributions. We thank you, and we continue to do what we hope you aspired this course to be, these discussions to be, and that you will look back and know that your investment was worthwhile. Thank you. So as we say au revoir to her, I also say good night to you, but I also leave you with that parting message that if each and every one of us walked out of here today and did our bit in addressing the stigma, the shame that survivors walk with or suffer, then we'll have made our contribution one step at a time. So I thank you.